Welcome to the New York City Bar Association podcast. Opinions expressed are those of the speakers and not necessarily of the city bar.
Welcome to the latest podcast from the New York City Bar's Presidential Task Force on Artificial Intelligence and Digital Technologies. I'm Katherine Hughes, co-chair of the Subcommittee on Artificial Intelligence and Legal Education. Today, we're focused on how artificial intelligence is reshaping what and how we teach in law schools, how we assess student work, and how we prepare future lawyers for AI-enabled practice. Joining me today are Dean Stefanie Lindquist and Oliver Roberts. Welcome to both of you. I'm absolutely thrilled to have you here with us. I'll just invite you to both introduce yourselves and say a few words about your work in this space. Stefanie?
Sure. Thank you, Catherine. My name is Stefanie Lindquist. I am the Nickerson Dean, a professor of law at WashU University School of Law in St. Louis. I've been serving in this role for 2 years, and upon my arrival in July of 2024, I made artificial intelligence my central kind of platform as dean in terms of pivoting the law school to an understanding of this technology, how it's going to change the legal profession, and how we're going to have to adapt to it in legal education. And so that has been, among other things, of course, I do other things as dean, but focusing on artificial intelligence has been number one on my policy agenda as dean, because this technology is going to change everything about the practice of law. I like to say that law is about language and precedent, and large language models are based on language and precedent. And so it seems to me we've got some work to do.
Great. Thank you so much. We're thrilled to have you. Oliver?
Thanks for having me, Catherine. Appreciate it. My name is Oliver Roberts. I'm co-director of the AI Collaborative at WashU Law and an adjunct professor at WashU Law. I've been working directly with Dean Lindquist on a lot of these AI initiatives. So it's been a pleasure doing that. I'm also CEO and founder of Wickard AI and also managing attorney at the Roberts Legal Firm.
Thank you both so much. I'm not sure how you all find time to do everything you do, but we're grateful that you're here with us. So, as you previewed, today we're going to be talking about the core themes that educators have been wrestling with in the AI space. We're looking at competence and ethics, assessment integrity, skills pedagogy, clinics and governance, and scholarship and journal norms. So, I want to start with what's changed maybe over the last 18 months or so. When did you feel that AI moved from a course level professor specific choice to an institutional level issue? I want to hear specifically about what spurred your really innovative approach at WashU. So, Stefanie, do you want to kick us off?
Sure. The impetus for my changes to the law school in reaction to artificial intelligence really came before I even started the deanship. I happened to be spending a week on a sailboat in the British Virgin Islands with a George Washington law student who was explaining to me all the ways in which he was using ChatGPT and other platforms to study in law school. And the only way I had used AI up to that point was to create Shakespearean sonnets of Supreme Court decisions. I've got a beautiful one on Brown versus Board of Education if you're interested, among others. But I realized at that time that the extent to which artificial intelligence and large language models were being used by students in law school was profound. And so that was my wake-up call. And immediately upon, as I mentioned before, upon becoming dean, I appointed an AI task force and joined forces with Olive, who cold emailed me out of the blue one day, probably within the first month or two of my deanship. And I've always thought that public-private partnerships were the way to move forward in a swiftly changing landscape, a technological landscape. And so Oliver helped ramp up our programming within a short period of time.
Great, thanks. And Oliver, what spurred you to write that email?
So my journey with AI, it goes back a little while. I started at Skadden. I was an attorney at Skadden for only 7 months at a law school, and then I left to start my first startup. I think it might have been like eight or 9 months, but I left to start my first startup. It was in the software space, so I hired a team of developers overseas, managed them. That's where I got my kind of introduction into building technology products. After that, I continued working. I worked at Jones Day for a little bit. That's when ChatGPT really came onto the scene. And I remember using it for a research assignment, just a generic question I asked the ChatGPT, something about a certain case, and it gave me a bunch of case citations. I like, this is fantastic and amazing. And then I realized when I went to cross-reference those in Westlaw, none of them existed. So this is very early on. This is before Mata v. Avianca, where I realized, like, wow, there's a lot of opportunity here, but a huge amount of risk. So that was my soft introduction into it. I was working with a co-founder at one point building an on-demand e-discovery tool. So we're also like building this technology, but quickly saw the need was more on the training side, both in terms of lawyers and law firms, figuring out how do we deploy this technology, how do we teach our lawyers. And then I saw an even stronger need for that in the academic setting. So I reached out to a couple professors, did some guest lectures at different schools, but then said, hey, this should be like a full mainstay in the academic programming at schools. So I reached out to say, hey, let's make this a full required course at law schools. And WashU was one of the first schools to give me that opportunity to work with them directly to roll out these pretty innovative programs.
That's fantastic. I love the innovation and the hard work that you've both put into this. Oliver, when you're working on these kind of course launches and you're working with other faculty, is there a singular common misconception that you see among the faculty when they first start engaging with Gen I as a teaching tool?
I think there's quite a few. I think at the admin level, there's the belief that if we have one course on AI regulation and it's an elective, then that's sufficient to cover the educational needs of teaching AI, which I think is pretty off base because AI regulation is distinct from using AI tools in practice, which is distinct from teaching personal and ethical responsibilities vis-a-vis the use of AI. So it's far more complex and broader than just saying we have one course on AI. It depends what the content is. What are you actually teaching? So I think that's one at a high level misconception in terms of the actual programming that schools are giving. When you get into actually teaching students how to use AI, there's a huge difference between lecturing at a student and saying, hey, this is Westlaw, this is Lexis, here are the AI features, and you just show what they are. Putting the tools in the hands of the students is very important for them to go through and see the limitations. And I do think the need is beyond just Lexis and Westlaw's Gen AI capabilities. Bring in vendors like Spellbook for contract drafting, vendors like Relativity to show e-discovery. So showing the functionality of Gen AI tools all across the lawyer workflow. I think that's very important. So I think those are just two misconceptions. Teaching AI in a way that's a lot more siloed. I think it should be covering the full gamut of how lawyers are actually engaging these tools in practice.
That's great. And I teach a clinic at Fordham, and I agree that it needs to be integrated throughout the practice, right? It's going to be part of the student's practice no matter what they go on to, and it's part of their everyday lives already. So thinking critically about the tools is really important and not just accepting them at face value. Is there a particular AI related learning outcome that every JD graduate should have by graduation? Could you put that into words?
Well, I can explain. I mean, unless Oliver, you want to proceed, I can explain how I think about what I'd like our students to have the facility in doing when they practice law. One thing I think that law school can do for students is offer them an opportunity to play in the sandbox. I know that's a loaded way of expressing this in the context of technology, but really get their hands dirty, so to speak, in the technology, learn to use it, learn to interact with it, iterate with it, and also build their own tools. I think that's the future. I was just recently on a podcast or a webinar with Oliver in which he was explaining how to vibe code. And so I think that lawyers are not just going to be lawyers in a bespoke relationship with their clients going forward, but rather also involved in research and development, data analysis. Law will become far more interdisciplinary, it seems to me, with the advent of artificial intelligence. And so I want to make sure that our students have the opportunity to build tools as well. And one of the things I did when I came to WashU was to bring the large language model engineer with me from ASU. He was my research assistant at ASU, and I was a master's degree in computer science and large language models. He came over, and he's full-time on our staff now to lend the engineering chops to any of these engagements that students or faculty or staff want to have with the technology. And so I think ensuring that students have the chance to really experiment is the key outcome I have at the moment for students. Through that experimentation, they will learn how to not only use the tools in legal practice, but also potentially build their own to fill voids and solve problems that they see in the practice of law.
That's great. That sounds like some pretty significant institutional support for faculty as we try and weave our way through this and trying to think about how we can incorporate these tools into our courses, whether doctrinal or clinical. So much appreciated that you're bringing in the power to back it up. That's great. Oliver, anything you want to share about AI related learning outcomes? I'd also love to hear a little bit more about what the elements are of the program that you've launched at WashU.
Hmm. Yeah, so I do think it's a moving target in terms of when you ask about what do you actually teach when you teach about AI and what credentials should someone leave with after they take the course. Because I mean, I think about a year ago, we're talking about how lawyers are going to be prompt engineers and how you need to know exactly how to prompt a model. But now at this point, even on general purpose models, prompting is probably like the easiest thing ever because internally they change what your prompt is to make it more specific and get you better answers. So we've now seen that kind of fall down the wayside where becoming a prompt engineer is not that significant. And I see some law schools that have rolled out like whole courses on prompt engineering. And I'm going to be honest, I think that's like kind of ridiculous and a waste of time. So what I think the core takeaways should be in these courses is one, figuring out what the AI terminology is. That is, students should leave and be able to define what is AI versus generative AI, what is a large language model, how does it operate at its core foundational level. You don't have to get into the too much in detail, but a general level and knowing that they're basically next token predictors, I think that's important to set the stage for understanding why they're so volatile and produce hallucinations. So I think understanding the core terminology and technology is important. I think it's then important to give students the ability to assess what tools are out there. It's often under addressed. Like if you're a lawyer and you're going to practice, do you know day one upon graduation like what tech stacks you're going to use, what AI tools you're going to use, or even just generally what billing software is there, what e-discovery software is there, how do you even pick? So I think that's important to show students that you have options that are free, you have options that are low cost general AI models like Gemini, Claude, ChatGPT. But then you have to couple that with teaching them that if you're going to use the free version, you might be compromising attorney client privilege. So there's a lot of different angles to this, but I do think it's important for students to know the difference between general model options and legal specific tool options. What are the pros? What are the cons? And then finally, I think it's important to teach the ethics and professional responsibility elements of it explicitly, although the models keep changing and we see new issues coming up like US v. Hepner, where we now see judges actually making rulings on whether data going into ChatGPT and Claude could result in the compromise of attorney-client privilege. Those seem to be novel issues, but they all go back to the core foundational principles of what is attorney-client privilege, what is your duty of competence. So teaching all of those core professional responsibilities and then setting that foundation for students, I think is important. And then take them through the specific scenarios that are playing out in legal practice right now to show them the issues that they'll face when they do use AI tools. So I think those are all things, while we have a moving target, those are core things that I think students need to leave with tangible learning outcomes involving those issues.
That's fantastic. I think, yeah, it's often hard to find a way to fit all of that into a semester or a year-long course and then to layer on the vocabulary of the technology on top of it. But that's really the only way that a practicing lawyer can assess what they're doing, right? To understand the technology and understand what it is they're signing up for. Perhaps read the privacy policies as they apply as well. This is a really great segue into my next topic, which is competence, ethics, and supervision. Dean Lindquist, I wanted to ask you, we talked a little bit about institutional support for faculty embracing these tools and this kind of revolution that we're going through. Can you talk a little bit about how we can translate professional responsibility expectations into school-wide AI-related guardrails? So that includes how we communicate as an institution, what the approved tools are, how faculty are trained, what the disclosure expectations are for using AI, because I think what I've seen anyway is that there's a lot of individual professor activity in this space, and that's just starting to translate into school-wide policy.
Yes, and I think there are some universities that have developed, and law schools even, that have developed more school-wide policies. What we've done so far is revise a couple of aspects of our teaching policies. Again, I think it could go much broader than this, and I appreciate the question because it's going to prompt me to do something about it. But we struggle with a number of things for our AI, the development of AI and how it might change our honor code. We didn't have to change that much because ultimately, what the scope of students' access to AI in any particular course and the tools is subject to the faculty members' syllabus. And so they can decide, I'm going to let a student use AI to draft first draft of an essay. That's really their choice to do that. But we did have to make some changes in things like take-home exams. We realized that there no longer can be, because you cannot detect whether a student has used AI or not, if we told students not to use AI and some students did, then the ones who didn't would be disadvantaged. And again, it can't be detected. And so we eliminated, with the exception of any approval that might be granted by the Vice Dean for Academic Affairs, we have eliminated take-home exams completely and changed the way that we manage access to the internet, et cetera, for our regular exams as well. And we moved to scheduled exams. So WashU, there had been a policy, and perhaps that's the case at Fordham, where upper level students can take the exam whenever they want. And we realized that posed risks as well. So we changed our policy there, and we now have scheduled exams so we can be sure to lock down the classroom. These to me are these are essential for legal education, and we have to think about these things. But to me, these are sort of the nuts and bolts and not nearly as interesting, as they have to be taken care of, but they're not nearly as interesting as the broader question of how we ensure that students who use AI in the process of gaining their legal education do not short circuit their ability to think critically. That sounds very mundane, and sort of dull thing to say, but it is extremely important because AI is so convincing, right? That you can just take it at its face value and assume that it's smarter than you are. And we have to ensure that the students understand that ultimately it's the human in charge and the human in the loop that's going to be making these judgment calls. And they require wisdom and emotional intelligence and all the things that human beings bring to the lawyer, to the attorney-client relationship.
Yeah, I think I have to agree. I think that's one of the issues that we're really fundamentally grappling with in the clinical space is what is the role of the clinic, right? Is it to teach students to be practice ready? Is it to teach them to think critically? Is it both? And how do we sort of balance this concept of productivity with the core risks that you would encounter in using any AI tool? And I know I've just come from the AALS clinical conference last week in Oregon. And yeah, it's a big issue. It's a big question. And how do we train people to use it responsibly? Oliver, a question for you as you're thinking through curriculum and decisions about what's included and what's not included in the courses that you're launching at law schools. When we're talking about teaching students to be AI competent, what are you including in that? Is it literacy with the tools, how to verify, what to verify? I mean, a lot of these concepts go back to the days when we were shepherdizing in law libraries, right? It's all of the same activities, just done in a different way. But I'm interested to hear a little bit more about that from you.
Yeah, I think it goes down to knowing the AI terminology, knowing how the technology works, covering the ethical and professional guidance. And I'll take students through I'll usually do when I teach the ethics portion, I'll usually present the scenario. So I'll give them a fact pattern and then say, is it A, is it B? Because I usually teach in bigger courses, like I taught other schools with like 150 to 200 people in a room. So I got to keep it engaging. So I'll give them a fact scenario, then I'll give them multiple choice and ask, what would you do in the scenario? And it's always a gray area where I'll actually get splits between two answers. And I'll give one example where it's like you use, I don't know, let's say you write a memorandum, you get a bunch of citations from co-counsel, the generative AI feature in Westlaw, you get all your citations back, then you run it through litigation document analyzer, which is supposed to be another check. And then I say to students, all right, is this an ethical use if you just go file this or send it to a partner? And people will say, yes, it is. You used a legal tech tool. You checked it through litigation document analyzer. But then I say, well, here's the curveball. You never manually reviewed it. You used an AI tool to check another AI tool. And here's a real example of an attorney that did this in this court, and he filed fake citations. So I'll bring them through a real workflow that you might engage in. Then I show students, here are the options. You tell me what the answer is. And then I show them that fact pattern actually comes from a real case where an attorney got sanctioned. So I think that kind of sets the stage. If you just lecture at students and say, don't do this, don't do that, they don't go through the thought process. They don't put themselves in the shoes of the people in that fact pattern. So I think that's one important thing, to put students in that scenario. Because when I was a law student, like, you learn about the rules of federal rules of civil procedure. You learn the rules about how to do discovery. But then I remember getting in my first case involving discovery. I'm like, what do you even do? I have no idea. How does document review work? So I really try to put students through the full workflows and scenarios so they could see how they're really going to engage with these potential ethics issues and AI tool usages in practice.
Yeah,
Let me just follow up real quick with something that Oliver said, and that is that Oliver's teaching students about lawyer workflows. And frankly, we don't, as a general matter, except in clinics, and those are subject matter dependent in terms of what the workflow is. we don't really teach students about how lawyers practice law on the nitty gritty, right? And I at this Alexis Nexus panel I was just on, the one of the topics of conversation was the sanctions that can be imposed all the way up the chain. So it's not just the junior associate making the mistake, but then his supervisor or her supervisor can be sanctioned, and then the managing attorney can be sanctioned. So thinking about for not checking on and supervising properly the use of AI at the very lowest level of that chain, that hierarchy. And so it'd be helpful for students to understand how project management works in law firms. I mean, lawyers are engaged in project management. That's what a piece of litigation is. That's what a major transaction is. And what that project management looks like at all levels of the hierarchy within it is really important to understand the implications for AI ethics as applied throughout that. So I think Oliver's point is well taken. And I think it's an important wake-up call for us in law schools that we actually have to start teaching about the business of law.
Yeah, I hear you on that front for sure. I think in some ways it feels like nothing has changed, right? Like if your name is on the filing, you own the filing. That's it, bottom line, regardless of what tools are being used. But at the same time, everything has changed. And students really need to come into the practice of law being a little bit more savvy about what the expectations are. It isn't just do the research, write the brief anymore. It's much bigger than that. And I think this is a topic for another day, but I think the business development expectations are there as well, how we deal with billing, all of that kind of stuff. It would be fantastic if law schools were engaging on those topics in a more fulsome way. Okay, I have one more ethics question, and maybe Oliver, this one's for you. Is there an area of ethics when you're teaching that students most overlook or underestimate? So I'm thinking about client confidentiality, hallucination, cybersecurity, tech bias, general embedded bias in AI tools? Is there something that they're just not thinking about?
I'd say the ones they don't really think about is the client confidentiality. And I don't think most lawyers have thought about that until the US v. Hepner decision recently.
Yeah.
So that's a new one I do integrate to kind of show students like this is the importance of understanding like when you select what tools you're going to use. Another one, I don't think students really think about cybersecurity. It's just not something that they encounter in the usually 1L or 2L curriculum. But I'd say one that they may overlook and they probably should not is the over reliance on legal tech specific products. I think most students now understand that general purpose models like ChatGPT, Claude, Gemini, they all hallucinate. But then they may think, oh, I use CoCounsel though, and that has linked citations and I could click and it exists. And then they think that's legitimate and I don't need to site check that manually. But then the concern is the quotations or legal propositions that come before the citation could be totally fabricated, could be totally hallucinated. So that's something that I still think students are over relying on legal tech products and not validating it because the tech products are getting better. They're grounding it in real citations, but those preliminary legal propositions and quotes, those are not grounded directly in the source. So you need to verify that 100% that they are. So I think that's one area that students overlook at the moment that could lead to other issues in
Yeah,
the future for them.
I agree. I think there's also this sense of like false completeness where, the document or the research or whatever it is that the AI spits out, it seems great. And it's not just a matter of checking sites or even checking propositions, but there's just underlying research that needs to be done and confirmed. And it's, I'm sure, going to get much better over the coming years, but there's certainly an element of false completeness that comes up. And then I think there's just like day to day practice, right? A lawyer who's been practicing in a certain area for many years will just know things about how the world works in their respective practice area or where a corner could be cut or where you have to make sure that's exactly perfect every time. And there's some nuance to that. So I appreciate all of the efficiency and the magnitude of the change that AI is bringing, but there is definitely still space for the lawyer and the lawyer's critical thinking and expertise to weigh in here. I want to change gears just a little bit. We talked before about assessment and how student assessment is changing through the implementation of AI tools and how faculty are thinking through whether and how to redesign the ways they evaluate student mastery. Beyond the division of take-home exams and in-class exams and the lockdowns on the internet and these kinds of things, I'm wondering if either of you have seen assessment formats that work really well. So in my clinic, I've moved a lot towards oral presentation, in-person meetings, things like that. I'm thinking next semester of including sort of stage drafting processes where I have the students write out certain ideas, certain outlines, that kind of thing before they just go to AI. It's a little hard to determine how successful that will be given the proliferation of these tools, but I'm wondering what your advice is on faculty who are considering reassessing how they work with students to determine their grades.
Well, the oral exam is a wonderful opportunity for faculty members, extremely time consuming.
Mhm.
And when you've got a class of 90 first-year students in constitutional law, it's near impossible. So, but I think in smaller seminars and things, the oral exam is a great way to enable students to hone their verbal communication skills, right? But also test their actual knowledge in their heads. So I think there's a real benefit to that. AI could potentially help with this. There are some wonderful tools out there to test students on cold calling, for example. And that we work with a company who has a wonderful platform for you can feed a case in there and it'll generate interesting questions that are quite sophisticated. I happen to use Marver versus Madison. I'm a con law professor as the prototype for me, as the test case for me. And the questions it generated were probably more sophisticated in some ways than the questions that I would have asked students in the course of a class period. So there's also opportunities to use those kinds of tools for students to test their oral skills, and that can be automated. And so, but I think your point about oral exams is well taken. Oliver, you
Did
were
you separately, just as an aside, did you see the news piece today about Neil Katyal's use of AI to prepare for his most recent Supreme Court argument?
oh, is that right? Did he use
He had a bespoke tool created, and I think I haven't seen he did recorded a TED talk, but I haven't seen it. But I
yeah,
think
because the covered argument can also be simulated. And it's really,
yeah.
I would say that the one big impact I'm excited to see in law schools with AI is the opportunity for simulation.
Mm.
We already use AI for negotiation now. In our courses, there's some wonderful tools out there, and you can create your own to simulate negotiations, et cetera, et cetera. So students learn. I'm a political scientist, actually, as well as a lawyer, and we've been doing simulations for a long time in political science. Model UN, we have a model constitutional convention at WashU, et cetera, et cetera. And those simulations are what students always explain
Mm.
to be the most impactful educational experiences they have. And AI offers us a great new, I think, brave new world in simulations.
What do you both think about the responsible use of AI in a writing or drafting class? I will be transparent that I required my students to disclose the use of AI before as they were using it in my class this semester. That was not a great success as an approach because everybody forgot to do it. And I ended up just talking to them verbally about how they were using these tools. But I'm interested to hear if you've seen anything that's been successful about documenting the AI use. Mostly what my goal was to just learn from the students and see how they're using it, at what level they're using it. But I'm interested to hear from you all.
Oh,
One thing we're prototyping, Wickard, and I sent this to Dean Lindquist the other week actually, a system where students write an assignment, they upload it to a platform, and the platform automatically converts their submitted assignment into a quick time quiz. And essentially, the premise is it's testing students on the content of what they just wrote. Because it's my perspective that these tools are available, students are going to use them and perhaps misuse them. And in reality, when you get into real practice in the real world, it's kind of what work product you deliver. If you're using an AI tool to do it and you deliver a better work product, your employer is probably going to like that. Your client's going to like that as long as the quality at the end of the day is better. So I think it goes down to the quality. But then in an educational setting, you have to teach people how to actually write the structure and to use these tools and not eliminate the ability of students to actually learn the content of what they're writing about. So the premise of that platform is, yes, you could use AI. There's no limit on that, but you need to know what you're actually writing. The substance and the quality has to be good. So that platform would convert a student's written assignment into a quick quiz, and now you're quizzing them on the content of what they submitted. So if they used AI to write the entire thing, they're not fully going to understand the concepts, or not going to not know what they just submitted, and they do poor on the quiz, and then you factor that quiz into the grade. So that's one way to actually to assess what a student submitted if they know what they just submitted. That doesn't necessarily get at like the structure of the writing, how quality it is, and that would still be something within the purview of a professor to decide and read. So that's one possible solution we're iterating over at Wickard. We'll see if it catches on anywhere. But yeah, I don't really have a problem if students are using AI to help improve spelling, grammar, structure. I think I'd rather have someone have better writing with AI than someone do it all on their own and have very poor writing and submit something that's hard to read, hard to follow. So that's where I kind of strike the balance, but it's definitely a difficult topic to address.
Yeah, it
You're-
levels the playing field, right?
It does. It's a question of what skills can we leapfrog. On a panel recently, I noted that people are now lamenting the fact that children don't learn how to write in cursive anymore. Well, I don't know that cursive handwriting couldn't just go by the wayside. I think there's an argument that it somehow translates into thinking, facilitates thinking or something. I don't know what the arguments are, but I joke that we don't teach people how to create cuneiform with styluses on clay tablets anymore either. Do students need to understand all the detailed rules of grammar now if those are going to be automatically corrected, noun, verb, agreement, things like that? I think we really have to think hard about what can we leapfrog. If you're editing, so recently I had to write an introduction to a journal of a symposium that I had curated for one of our law reviews at WashU. And it was just a synopsis of the various articles and explaining how they integrated with each other. They're about AI. And of course I used AI to produce a first draft. I didn't have time to do it myself. There's benefit in faith in that white page and having to figure out what you're going to do. It takes grit to write. But producing it in AI, I put a note there that it was written with AI at the bottom of the piece. But boy, it produced some magnificent proposals. And in many ways, better than what I would have produced. So the question is, can we leapfrog those writing skills and move right into a higher order thinking about the written work product that gets at the content, the structure, etc., without having to do the line editing that I've had to do my entire career as a professor? Omit needless words was something out of Strunk and White. You may remember that. And I've written that thousands of times on essays. Due to the fact that I always try to get students to eliminate that, because Strunk and White didn't like that either. Maybe that's no longer, maybe that was an exercise at the time necessary, but no longer.
Yeah, I mean, as somebody who was deeply involved in law review in my many years ago law school time, the Blue Book comes to mind. And I know great training comes from going through running those paces, but there's probably some other more substantive thinking that we could dedicate that time to in a more productive way. We talked a little bit just before about teaching students to think in workflows. Oliver, can you talk a little bit about how you introduce that concept to students, what that looks like? I have the feeling that as the years unfold before us, thinking in workflows is going to just become second nature to everyone. But what are you encountering right now and how are you implementing that?
Yeah, I like to include that when I give examples because when you assign someone a workflow, I'll speak through an example to kind of make this more tangible. But it's important to like first assess what tools you're going to use, what could you leverage them for, what is the final work product they are actually expected to produce. So thinking through all that's really important rather than just telling a student like go use CoCounsel to do research and compare it to the traditional method of doing research through just the regular search, Boolean search. So I'll give an assignment, something like your summer associate partner just emailed you, and I'll put a real email up there. It'll be like short form. It won't be a concise email telling you exactly what to do. It'll be like, I just got out of a client meeting. Client wants to sue in this state. Client's actually based in that state. Research the potential cause of action. Let me know if there's any personal jurisdiction issues. So it'll be a little bit scattered all over the place. And then it's on the student first to assess, all right, what am I being asked to do? What am I delivering? I'm delivering a memo, but to deliver that memo, I need to address causes of action. I need to figure out personal jurisdiction issues to lay out exactly what you're being asked to do and also assess what's the time period. Is this a quick turnaround? Is this going to be something you have a week to do? So first assess what's being asked of you. Then it's what tools could I actually, what steps am I going to take and what tools could I leverage? So first, maybe I have to think through, let me read the fact pattern. Let me see what cause of action I took tort. So I'm going to think about negligence, but then, all right, maybe we could use Harvey or we could use CoCounsel as a thought partner to put the whole fact pattern in and say, give me a potential cause of action. And every time I do that and I make new fact patterns, I even see cause of action I wouldn't think about. For example, maybe negligence per se, because there's some specific regulation related to this amusement park where the injury happened. So I show students, like you're probably thinking this lane, think of all the cause of action you just learned in 1L, but using a thought partner as an AI tool, now you just open the world of opportunities to address these other potential causes of action. So it's using AI tools as a thought partner. Then you get into the research. You have to actually research those causes of action, find the case law. You could use traditional search side by side with an AI agent to also research alongside you. So that's another step now using AI tools in a research capacity. Then you're now moving on to drafting, which AI tools can you use to help give a format for a memo. Because even it's basic stuff where a student might not even know, maybe you have to draft a motion to dismiss. What are the sections of a motion to dismiss? If you ask a 3L at most schools, I don't even think they'd be able to tell you. I remember I didn't even know when I was graduating. So now you could actually use an AI tool to tell you what's the general format of this delivery that you have to deliver. Then you can use it for drafting assistance. So it's taking students through the full workflow, because to say, let's use AI tools, there's so many niche areas in which you could use it along the path of a broader workflow to work a lot more efficiently. And I could almost guarantee I'd rather have a work product where a student actually used AI all throughout the process in effective and responsible ways, rather than someone who just took it and put it into like ChatGPT or did it without any AI assistance. So that's just an example of workflow and how I teach students like choice of tools, where it delivers value, and how you could ultimately get to the end work product.
Yeah, I love that idea for the clinic, especially we do a lot of simulations in the seminar, and I think the idea of like, let's design a workflow for this particular issue, I think would be a really great hands-on activity. I have a question for both of you. Have you encountered any skeptical faculty? Is there anybody pushing back on integrating AI into the curriculum? And what do you say? How do you handle that?
I'm pleased to report that most faculty, certainly among the legal research and writing faculty, there's no hesitation about the need to understand the uses of this technology. Among the tenure and tenure track faculty, I think most of them realize this tsunami wave is approaching, and we better get our scuba gear out or back down the hatches or whatever we need to do. But the interest in the technology varies substantially among them. So some are more interested in the ethical, academic integrity issues, and that seems to be sort of where their interest stops. Others are interested in using it to help facilitate the classroom experience for students or their own research. And so there's a tremendous variation among faculty. I think the efforts that we made at WashU with Oliver's help have sort of we built that as an initial effort out of the dean's office. And then it sort of built and developed its own momentum. And now the faculty is also very engaged in some aspects of that program that we've built.
Okay, great. Oliver, anything to add on that front?
Yeah, Dean Lindquist and I, we actually wrote an op-ed in Bloomberg Law back in the fall of this past year, 2025. And we made the point that there was one professor, and I don't think it's just one professor, there's a lot of people that have this perspective. The professor said the AI tools he was referring to Lexis plus AI, saying that the AI tools aren't good enough, therefore I'm not going to teach my students about it. And we wrote how that's just the wrong perspective. It's the legal profession that dictates what tools the legal profession is going to use. What law schools say about AI is not going to change what Skadden, Arps, or Jones Day does out in the real world. So if out in the real world, clients are demanding AI tool use, law firms are demanding it, how could a law school say we're not going to teach it and make the own subjective assessment that they're not good enough? And then we further made the point that if the tools aren't good enough, teach students that, show them the limitations, show where they're not good, so students don't end up committing ethical missteps by misusing them or over-relying on them. So I think even if you're opposed to AI tool usage, that's kind of the reality it's being used, and you should just teach students the benefits and the limitations at the same time.
I have to agree with you on that front. And when we're thinking about using AI in practice, I want to turn to using AI in the clinical context. And we've talked about what the boundaries are around that, what the ethical issues are, and those considerations. And one of the, I think, concerns that people have is that in the clinical space, we know that we need to be teaching students how to use these tools, but sometimes we don't have access and insight into how the institutions are deciding which tools are okay to use, which tools are safe to use, all of this kind of stuff. How do you handle that? Like, how do you cross that bridge with clinicians to encourage them to use the tools in a way that is safe for client work?
Well, so as of right now, Catherine, that is up to the individual clinics. But I will say this, and we have yet to have major conversations, although I'm sure they're coming in the coming year, about how AI can be deployed in clinics. We do have, however, some high volume clinics that, for example, process many taxpayer issues and that sort of thing, and many of them are repetitive. And so building work models or LLM models that can help them process these multitudinous, repetitive cases could be very helpful in the clinics. One of the guys on our advisory board has a platform for workers' comp cases because workers' comp is a high volume practice area, obviously. And how do you make that as efficient as possible? And meanwhile, giving those cases as much individualized attention as you can. But I think going forward, and Oliver, I'm just going to put this in your brain. So in the coming year, we can think hard about how to elevate AI in the clinics, although I know they're already thinking about it. But I think it's the question of the hour that I get asked, almost every interview. I need to get a better answer.
Yeah. Fantastic. That guidance will be well received, I assure you. I have just a couple of questions left for you. We talked about kind of the varying range of interest in adopting AI, and one of the core job duties is scholarship and producing scholarship and really thinking innovative thoughts and documenting those thoughts in order to move the needle forward and changing our world. How has the Academy's approach to scholarship changed? Have you seen changes? Are you seeing journals respond?
So it's interesting you asked that question. The way that I have seen it change is that we have a number of faculty members who use AI to process mass quantities of documents. For example, studying SEC filings, and you really need AI to pour through those for you. It's no different than using relativity for the e-discovery process, right? And so we've certainly seen an uptake in the use of AI for those purposes. We also have faculty members conducting all kinds of interesting research about how AI grades exams relative to humans. And frankly, AI does an excellent job. I'm not sure if you've been in a rubric, you can be pretty sure they might be even a little more uniform in their grading standards than human beings are. So we do have faculty members who are really deep into research on AI and privacy, AI and employment. There's just all kinds of work that's being done that either intersects with AI, the regulation of AI, or intersects with AI and the use of the tools to conduct empirical research projects. And I think that is all terrific. I do have concerns, though, Katherine, about the future of journals. Because, faculty members are going to continue to draft interesting articles and they will come up with good ideas, but AI can too. AI can produce amazing hypotheses related to behavioral research, for example, and can produce hypotheses building on hypotheses. And so journals are interesting. The other problem with journals, as you probably know, is that employers now, at WashU anyway, are trying to hire our students before they even, write onto a journal. And they have jobs in January of their first year for their second year summer. There's no doubt in my mind that eventually they're going to ask themselves the question, why bother with a journal, right? And so I am concerned about the future of law reviews as a laboratory for students to test out their writing and editing skills.
Yeah, we've encountered the same concerns here. And those of us who lived through that gauntlet, there's so much learning that happens.
So much. And leadership.
Yeah.
And I was editor-in-chief of my law review. Let me tell you, that's where I cut my teeth on leadership. I made a ton of mistakes.
Yeah.
I was 25 years old or whatever I was. And I still apply some of those lessons learned and what I do wrong.
Yeah. And being in the trenches with those people, those are bonds that last your entire career. So yeah, we'll watch this space to see how it evolves, but certainly something that I'm very interested in. So I just want to close out. My question for you in closing is really, what's the piece of advice that you have for both faculty members and students as we really crest this wave of technological revolution? Is there some advice, given all that you all have been doing on the front lines, that you would wish to share?
Well, I'm happy to jump in with my standard line. And I think Oliver and I have slight disagreement about this, about whether or not lawyers are going to be replaced by AI. There is no question in my mind that AI is going to bring pressure to bear on pre-existing business models in law, and that will change the apprenticeship model and everything else. And so we have to prepare ourselves for that new future in law where the entire business model changes. And that will change how law firms hire. That will change the kind of apprenticeship that students receive when they graduate and all that. But I remain convinced that law is, at its foundation, a human business. Clients want the wisdom, right, and the expertise that comes, as you mentioned previously in this podcast, with experience of litigating. And a lot of that can be gleaned from AI. So no question, you can find out how a judge decided in a statistical analysis with AI on every patent case he or she ever decided. You can conduct the risk analysis, the probability analysis that you might need. But I do think that lawyers' wisdom will prevail as a useful skill. They will not be eliminated from the landscape. Having said that, I always say that AI will not replace lawyers per se, but lawyers who don't know how to use AI will be replaced by lawyers who do. And so that is my mantra as dean and why I feel it's our duty. And I mean that seriously. It is our duty as legal educators to be sure that our students know all that they can coming out of law school about this technology, including its risk to humanity. We haven't talked about that, but I'm just going to add that in as a last sort of tiny note.
I was feeling a little bit comforted, and then you mentioned risk to humanity, and that opens it all up again. Oliver, anything you want to add?
I think I agree with that. I think it's the duty of law schools to be teaching on AI, the risks, the benefits, everything with respect to both the risks and benefits. And I do think leadership will probably face resistance. You'll have faculty that don't want to teach this, but I think, and I didn't mention this earlier, but I do think a lot of faculty, perhaps more tenured track, who have not recently practiced, who don't necessarily have a strong incentive to go out and rechange their entire curriculum to meet the needs of the current AI wave. So I think you are going to get resistance from a lot of people on this, but I do think it's still the duty of leadership to recognize that, to address it, and still be able to teach the next generation of lawyers. Otherwise, they're going to go into practice fully unprepared for what the real world actually demands these days.
That's great. We'll leave it there. Thank you both so much. You really are innovators on the front lines here, and we're really grateful for your insight and your time. And I look forward to working with you on all of these topics in the future. Much appreciated.
Wonderful to meet you, Catherine.
Thank you, Catherine.
Thank you.
Thank you for listening to this episode of the New York City Bar Association podcast. Opinions expressed are those of the speakers and not necessarily of the City Bar. If you enjoy this podcast, please like and subscribe wherever you listen. Find more City Bar podcasts on Apple, Spotify, YouTube Music, iHeart, or at our website at www.nycbar.org/podcasts. Be sure to check out This Lawyer's Life, a professional development podcast where we talk with lawyers about seizing opportunities, learning lessons the hard way, and about what makes them tick. And don't miss Building Belonging, a podcast that embraces authentic conversations about DEIB solutions by amplifying the most marginalized voices in the legal industry and exploring spaces others dare not. This podcast was produced and edited by Eli Cohen and Jalen Martin.